Hello, everyone, and welcome to Age Gap Love Story. We are Carrie and Alan. We are a married couple who has a 32-and-a-half-year age difference. And I think today we may have our audio working. We got these mics. Last time somebody said, I think your audio might be being picked up by your camera. And I think that was the case. So third time's the charm. Maybe we'll see. But today we're going to be talking about estate planning for age gap couples, a very non-sexy topic, but something that's very important in today's world. And somebody asked us to address this question. And so Alan and I had recently done an update on our estate planning, which is something we recommend that you do every few years, maybe every 5 years at the probably the longest. But it's something that once you do, it's not that bad, and then you can just update it. And I think we'll talk about some basic things, and then we'll talk about some specific things for age gap couples, and then we'll probably touch on like what not to do. And so we just want to remind you, we're not attorneys or whatever else. We're just kind of offering our experience and our advice. But this is a pretty basic topic. I think you can find an attorney fairly easily, and it doesn't even have to cost that much money to get it set up for yourself. So try not to let that be a impediment to you taking care of your estate planning. So maybe we should talk about like what basic estate planning even means.
Well, estate planning essentially is to provide a plan. So on your demise, and this may come as a shock to you, but we are all going to die sooner or later. And that's a touchy subject for a lot of people, but it's a normal part of life. So anyway, you have to plan for it. And whether you have a lot of assets or little assets or no assets, you should still have a basic estate plan, at a minimum, a will. And the purpose of it, again, is to lay out instructions as to your wishes after you're gone, as to what assets, if any, go to whom and under what conditions. And if you do have a larger estate, you have a house, you have equity in, you have investments, you have a 401k or some retirement plans, you should also have probably a living trust. Living trust meaning that you created while you're alive, and it is revocable or amendable as opposed to irrevocable or unamendable. Anyway, I don't want to get too technical, but the bottom line is you want to have a trust and a will, if possible. You should have a directive regarding your health care as to your wishes towards the end of your life. Do you want to be resuscitated if you go into a coma and you're brain dead? Or do you want to be allowed to pass? I mean, do you want to be in a condition where you suffer for a prolonged period? This is a medical directive, and there are forms that help you define this. And then lastly, you want to establish a power of attorney for those that are important to you that can take charge of your affairs. If you become incompetent, become ill, or just want to turn your affairs over to somebody else while you're alive.
That was a good overview.
Why, thank you.
Are you sure you're not an attorney?
No, but I think I'm still alive.
Yeah, so Alan just mentioned the 4 components. So I think that makes it simple because it starts to sound confusing. I was very confused about it for a long time.
In fact, I believe that there are forms that you can download from the internet. If you don't have a particularly large estate, you can download these forms after you filled in the blank spots. I think they're available. I haven't looked personally, but they're probably available either for free or a small fee. And I'm assuming you could fill them out online, print them out, and sign them in front of a witness, a notary public. And bing, bang, boom, for virtually no cost or little cost, you have a basic estate plan.
Right.
Now, if you have substantial assets, you probably would want to involve an attorney.
Right. So the 4 points that Alan mentioned, just to review: a will, a trust, a power of attorney, and a healthcare directive. So I think now that you kind of understand, and I understand, that it doesn't have to be that complicated. Probably the thing that makes it more complicated, and probably with age gap couples, is because then there are potentially children involved, maybe from a previous marriage. And then it can just be, I think, an uncomfortable conversation. And a lot of the younger partners in an age gap couple, it takes a while. You meet the love of your life, and then you kind of have to come to an understanding that probably the most likely scenario is that the person who you love like the most in the world is probably going to be gone before you are. And so then it starts to get into kind of this realm of acceptance and emotional kind of decisions, and um,
Yeah.
being comfortable talking about things like this.
Yes, there's one caution that I'd like to uh, make clear here, and that is in the legal profession. I learned this from a close friend of mine who's a retired attorney, that you don't want to be involved in what's known as the hand from beyond the grave. And that's where you create an estate plan where you lay out so many details and so many requirements and so many tricky things that it just is a nightmare for the people that have to settle your estate and your heirs.
So I want to comment from our perspective, or from our situation as the younger partner. Obviously, for me, it's been important for my emotional health and my security about the future, for Alan and I to talk about this stuff from the very beginning, and for me to know that Alan wants to make sure that I'm taken care of when he's gone. Because it is just a different situation when you're in an age gap relationship, because Alan has children from his previous marriage. So it's been really important for me to know that I'm going to be secure. So I'll just say that. So when we've made plans, or when Alan's made plans, um, we've just talked a lot about it. So if you're in this situation, yeah, everybody's situation is going to be different. Obviously, we're not going to tell you what to do or whatever, because everybody will have a different scenario. But I think the communication is key, because if you are having feelings of insecurity, or you're frustrated, or you're worried, then that's going to spill over into your relationship now. So I just think, like, try to pick an appropriate time to talk about it. And probably, like, in the attorney's office is not a great place to do it, because these conversations can be very delicate and
And it could be
personal.
expensive. If you're going to do it
Yeah.
in front of an attorney, the meter is going to be running, and it could be anywhere from $300 an hour to $600 an hour, depending on the attorney.
Yeah. So I would say to, broach the subject with your partner and say you'd like to talk about it when you're both feeling, well rested and secure, and that you can talk about, like, what do you hope to achieve
Make
from
an
the conversation.
Yes, and make an outline. So when you go to the attorney, you can tell them precisely what it is you want to do,
Yeah.
ask for their input to see if it makes sense, and then you have a plan.
Yeah. And I think one thing that's interesting is the attorneys have a lot of leeway in terms of, like, they have to follow a basic outline, but they can put in certain things. Like, if you have a certain concern about, a child from a previous marriage, or an ex, you can actually address those things within the document. I think that goes into a trust, but it could probably go into a will as well.
I mean, there are cases also where if there are no children involved from a prior marriage, there may be a family member of one of the uh, two partners here that is in a situation that needs care, and provisions have to be made for that care after one of those partners dies,
Mm.
depending upon who they're related to. So there are a lot of different issues that don't just involve children, but other considerations.
Right. So, and then Alan wanted to mention a document that he made, which is not a legal document. I think we've mentioned it before in one of our previous videos, but I think it's probably good to talk about it again.
Yes, I call it, for lack of a better term, the pop-off letter. When I pop off, when my little feet fall off the branch that I'm clinging to in life, that there will be complete, detailed instructions. A lot of people pass away, and the access code to their computer, to their phone, email, a lot of those things get lost, and it creates a real problem, for the survivors. So you need to put down everything. If the husband or the wife handles all the bill paying, you know, list all of that out. How do you do it? What insurance policies do you have? What brokerage and banking accounts do you have? What are the contact phone numbers? If you have an insurance policy, how do you contact them? I mean, there are all those little bits and pieces of life that one of the two partners handles on a daily basis that the other partner knows nothing about. And when, boom, if they're gone, whether it's suddenly or over a prolonged period, somebody has got to pick up, the ball and start running again. And there are things like on the calendars that individuals have about maintenance of things around the house, renewal policies, things that have to be paid, pending bills, pending follow-up. I mean, there are all kinds of things.
Yeah. There was a book, and I can't remember the name of it now. It's something about like the um I'll find it and I'll put it in the show notes or put it in the description. And it it is written by a doctor who I think has worked in hospice before. So he talked something like the beginning, or how to essentially like how to prepare yourself for the end or something like that. And it talks about some of these basics of like legalities and stuff, but then it also talks about kind of the medical process of passing away. um, it sounds a little morbid, but I felt like the author handled it really well. There were two authors, so I'll link to it. I got it from the library, but I might even buy a copy just because I thought it was so well done and practical. And this doctor mentioned that I think only about 20% of medical cases are when of death is that when, and let me see, 20% of the time is when somebody passes away suddenly. So the other 80%, there is some time to get your affairs in order, but that is not the time to be, setting up a trust.
Yeah, people are medicated,
Yeah.
they're in pain, they're not thinking
Yeah.
clearly. So the time
Fearful.
to do it, there's no better time than now.
Yes. And don't make it a huge thing. Just get started. Like, reach out to an attorney or ask a friend for a referral. I think doing it with an attorney is probably the easiest way.
After you made an outline.
Right. After you've had the discussions. But it really, try not to make it more complicated. And at least you have something to start with. And I would say, moving on to kind of like the mistakes to avoid, like just assuming that things are going to work out
We
is
know,
bad. It's
yeah,
not a good idea.
yeah, I've known people over the years that keep putting it off, keep putting it off, keep putting it off because they
Yeah.
don't want to address the concept of dying, or they think it's such a complicated process. They just don't know where to start. That is not the case. You start by grabbing a pad of paper, a pencil, and listing what it is you want. And you go from there, or look online at sample wills and trusts and healthcare directives. It's all out there.
Yeah.
You
Again,
know,
it's just the four components is all you need to do. Um, So it really is not that big of a deal, and it's going to benefit you and your loved ones.
Yeah,
So
and
it's almost like a gift that you can do to the people you love the most, and it's also honoring your life too, because everything you've worked so hard for, you don't want to be giving it away to a court or to an attorney. So think of it as just something really important for yourself and your loved ones.
and one other very important aspect is that at the time of one of the partner's death, the survivor is stricken with grief, overwhelmed with what to do, and that is a very delicate time when they go to arrange for burial plans. And that is a point in time where these entities that provide that service take advantage of the survivors who, again, are suffering with grief, and they sell them expensive funeral plans and layer on all kinds of other services. What I have done personally, I have a prepaid cremation plan that I signed up for years and years ago. And I have a card in my wallet. Something happens to me. Carrie calls the phone number. They come and take me away. And Carrie gets a nice little urn with ashes in it. And it's very easy. It's all prepaid. Bingo, bango, it's all done. So that might be something you want to think about. But if you're going to be the survivor, that is going to be one of the terrible, and I mean terrible, things that you're going to have to deal with are the burial plans. And again, you are very vulnerable at that point in your life.
Yeah.
So it's very wise to prepare ahead of time for it. Believe me.
Will you do that impression again? No, you're like this.
Oh, I'm not sure if I'll look like that. I might look like this.
Oh, okay. I don't know.
We'll send photos at the right time.
So, I also want to mention that I do think if budget is a concern, that there are some low cost legal low cost legal firms, I think. So assuming that you're going to have to spend a ton of money for this is another mistake that you could make. I think, and then as Alan mentioned, like having just a bunch of various accounts that only you know about, and just kind of having your estate disorganized with a bunch of different accounts everywhere and different passwords, and like that's just doing yourself a disservice.
When I was a stockbroker many years ago.
You're gonna mess up the mic.
Oh, sorry, I had an itch. When I was a stockbroker many years ago, I had an older couple, were clients of mine. And I remember the husband telling me, this is before they became a client, that it was an occasion where he had a stroke. And he was struggling because his speech was impaired to tell his wife, as he was in bed suffering from the effects of the stroke, where different things were located, like trust deeds that he had invested in and other documents, and he couldn't get it out, and how stressful it was for him. So when he recovered, he made a plan to get everything organized, put in one place, so his wife knew where things were if something happened to him again.
Right. So don't forget about things like retirement accounts, Social Security accounts, long-term care planning, life insurance. I think this is where it starts to get confusing. And so this is where, like the letter that Alan mentioned, once you start to kind of put everything in one place, then it's not as confusing. But if it's only living in your head, then that's going to make it confusing, and then that information is going to be lost.
Yeah, and one small point is a lot of people have documents and they put them in a bank safe deposit box, which is okay, but a lot of banks are not offering that service anymore. But you don't really need that as long as you have a small fireproof box at home. Or what we do is we have everything scanned and we keep it in Dropbox in the cloud, so we can access it remotely. And the hard copies are good, but you don't need to put them in a safe deposit box, because in most states, when one of the persons dies in a couple, you're supposed to notify the appropriate estate or inheritance tax authorities and notify the bank, and they put a seal on that safety deposit box so you can't get into it.
Mm.
So if grandpa's coin collection that's worth $80 billion is put into that safety deposit box and one of the two of you are gone, you can't get grandpa's coin collection out of there before the inheritance tax people get into that box after it's been unsealed and make an assessment as to the value. So, there are just a lot of little bits and pieces.
Hmm. Who are inheritance tax people?
The state, usually inheritance tax refers to a state, and estate tax usually refers to the federal government.
Mm.
But you're supposed to notify your financial institutions when one of the parties dies on a joint account.
And then they make a determination of the
Yes,
tax
yes,
situation?
yes. Well, it depends. I don't want to get into the details on it, but usually, if your assets are held as joint tenants with right of survivorship, that's
Oh,
one thing. But if they're held in the name of a trust, that's something else, and that's an issue that your attorney would have to explain to you.
I see.
Yeah, the best way to hold title.
I see. Okay. So hopefully that was a good overview. I want to challenge you who's watching. No, we're not chastising.
Oh,
We're setting a challenge to start the process this week. Start the process, have the conversation, ask around for an attorney, or do one step this week and report back to us in the comments or in our Facebook group. And just a reminder, we're not posting the audio anymore on the podcast platforms. We're just here on YouTube. I didn't get much feedback on doing like a live video, so we'll probably shelve that for now. And what we might do is start doing some interviews with other age gap couples, but we're not quite there yet. We have a lot on our plate as far as other projects we're working on my other business. Essentially, I'm busy with other projects. And
I'm not busy at all.
yeah, no.
Feel free to call me.
Yeah. But um anyways, we hope you enjoyed this episode, and if you have a specific topic you'd like us to cover, then let us know in the comments. We'll see you next time.
Bye-bye.
Bye.